thank you, Mr. Piyush and the TNI team for giving me this opportunity to speak on this public platform. And good afternoon to all of you, all the participants for joining our this session. As already introduced, in this session, we will walk a journey basically from a novel idea to legal protection patents. Now, this patents or legal protection, these words seem to be very difficult words for a common inventor or a common person or even a common professional. So in this session, I have tried to keep this session as simple as possible without any, legal dictionary words. It is very simple and, going to be, I hope it is going to be very interactive for all of you to understand the journey, how we can take it from a novel idea to a legal protection. Now, first of all, what do you mean by novel? Novel means new, any idea which is new. Now, what I believe is that, anybody on this earth, on this mother earth, is a born inventor. Each one of us is a born inventor. Actually, inventing something is already in our genes. The thing is, we don't pay much attention to that because we sometimes, we ignore, sometimes we observe, but we don't pay attention because of lack of our awareness. So, for to become an inventor, there is nothing, any academic degrees required. So you need not to be a PhD or scientist to invent something. Newton did not have a PhD degree to invent or to understand the phenomena which was already existing in the nature, that apple is falling because of gravity. And further, because of that gravity principle, many inventions came into existence or we humans developed. So it's not like that anybody who has developed those inventions, they were like, of course they were genius. Their geniusness was because of their observation, because they paid attention to that. Now, to our wonder, that our mind, it's always full of traffic of many ideas. Can you guess in one day how many ideas our mind actually thinks? I was surprised to check this data on the internet, when I was checking that, actually our mind, how much we can think. Our mind actually can think 60,000 to 80,000 thoughts per day. Now, these thoughts are mix of positive thoughts, negative thoughts. Now, we need to filter out that which thoughts have to be taken. I'm not going spiritually, but I'm telling this because out of those positive thoughts, only your ideas will be generated. Now, just imagine if a person thinks one productive thought, converting it into an idea in one day, in 1 year, actually he can become inventor of 365 inventions. And this is not a wonder. Anybody can do this. To prove this, I have many clients. Even a 5-year-old child invented a device. Now, everybody would be surprised that how a 5-year-old child can invent. He invented because of his observation. He observed a problem and then he was curious to solve that problem. So our mind should have observational skills plus curiosity to find a solution of that particular problem. So, of course, now next question may come into your mind that, can I be the inventor? Who can be the inventor? Who can invent? 5-year-old child to a teenager can invent, because I have, well-proved examples in my client portfolio. One student, I'll just give you the example. He got a national award from Indian government. His name is Aryan Tanwar. He's studying in class 7. He invented smart school bag. So the invention has really not to be, like super invention. We always think, okay, now these days robotics is getting trendy or artificial intelligence is getting trendy. So we don't have knowledge about that, but at least you can have idea. These technologies can be implemented once you must think upon an idea. Now this student, he might have thought of, making a school bag, converting his school bag, regular school bag, into a smart school bag. So this is how, he became an inventor. Actually, I should say he's already an inventor. Any professional, it doesn't matter that if you are, from non science background, or you are into academics, or you are into, arts or literature. Even a housewife, working in a kitchen, she is surrounded by so many technologies and she gets so many problems while working. If she pays attention, she can, of course, become an inventor, industrialists, entrepreneurs. Now, in many big companies, we often see that there are special teams, training each of the individuals or team members of the big industries, that you should, bring up something. They have special research teams to solve a, problem, or to update the technology, or to bring up really something new. But I would say before all those trainings, we must pay attention to our observational skills and curiosity of our mind. Senior citizens or retired professionals can also be the inventors. One of my clients, he had further referred, he told me about this case. I did not directly handle this case. So that, senior citizen, he's a 85-year-old man, and he got his invention patent granted. He developed an Ayurvedic formulation. So it was really, very surprising for, a common man of our country, actually, where we think that, okay, only the research professionals or scientists, so only they have the responsibility to solve a particular problem. But if, out of 132 crore population, even 50,000, people start thinking in a way that we have to solve this problem ourselves, then we need not to go to the foreign markets to outsource or to get their services. We need not to make, to get the ready-made materials. Now, for example, for the defense weapons, we always take, foreign countries' help. But if in this country, in our country, if we think that, okay, for any problem which we feel that we can solve it ourselves, a lot of cost can be saved if we, do not require really to outsource our problems. Any individual can invent. Now, after thinking that, okay, a particular idea is, novel, or now, I have invented something, what you need to do next? What next step? Just like you purchase a physical property like a house or a flat or a property, anything, you always rush to register it on your name or your family's name. Why? Because you don't want to get it stolen. You don't want that any person or any stranger, or I should use the term infringer, they should not get it registered on their name. Or if I'm renting out my property, that physical property, to someone, so that person should not become the owner of my property. So we always go to the court to get it registered. Similarly, we need to protect our idea. Why? We need to protect it because we don't want someone else to own that idea. Now one may think that, okay, we have got an idea. Why we would feel that, we need to legally protect it? That's okay. We have thought upon an idea. So why we should go? If you have an idea and that idea is really fantabulous, then of course you can develop a product of that idea. Now, after developing that product, you can become a jobs creator rather than seeker. Even in countries like US, their 9-year-old child could become CEO of her company because of one simple idea, one simple product. She made a dryer for drying hair of a dog. So any idea is never a small idea. You don't even realize that a small idea can actually make you big. So even if a student, if he is trained, or he really pays attention and he invents something in his school days, so he can be entrepreneur, he can sell his that product, and he can start his own company. So this is how the problem of less jobs can be cut off if we pay attention to brainstorming ideas. Now, for legal protection of your physical property, you go to the court. For legal protection on your idea, where one should go? There are two terms: patent agent and patent office. Now, the inventors, they often can get confused that where they should go actually. So there are two options. Inventor can himself go to the patent office. He will submit. Patent office is an office where you submit your applications for the patents grant. Now here I would like to put emphasis that just filing or submitting an application for the patent rights does not mean that you have you have got the patent rights, that you have got exclusive rights. So patent is exclusiveness, exclusive rights, that nobody else can actually use your idea, nobody else can sell your idea without your permission, nobody can copy your idea without your permission. So this is basically exclusive rights which are granted in the patent office. Now, there in the patent office, you might be unaware of so many things, like we hire a lawyer for registering our physical property, so we can go through a patent agent. Now, an agent, he is aware of all the laws, sections, rules of patent law. So he will advise you for a particular idea, really you should go to file patent or not. Because filing for the patent actually involves lot of time, effort, and of course your money. So in eventually later on we will discuss that how much time or cost are involved. So here I would suggest that one should go through the patent agent, because patent agent will prepare an application for you. He will submit your application along with filling up some forms to the patent office. Okay. Now, now you have thought an idea, you have an idea. Now you have also decided, okay, to a particular patent agent you will go. Now, for the patent agent, there are some patent agents who are, facilitators by Indian government in the Indian Patent Office. So you can also take their help, or you can go through a law firms. There are various firms who have, just like lawyers, there also patent agents are there. Now, what you have now gone to patent agent. Now you need to check that are you really prepared for question and answers round with the patent agent, because he is going to ask you some questions. Now, more time you will buy his time. In US, Europe, patent agents or attorneys, they charge as per the time. So if you are thinking to file patent application in US, Europe, so you can file your patent applications, anywhere worldwide. Now, for India, you will basically go to a patent agent, in Indian patent agent. For US, you will go to US patent agent. And also here, I would like to tell you that patents means territorial rights. If you have filed your patent application in India, your rights of exclusiveness, I just told you that nobody else can use your invention before your without your permission. So that will be within India only. So they will not be active in US. In case you want to do marketing in US, then you need to protect your idea in US also. So for this thing, so you should be prepared before interview with your patent agent. Now, what will be the first question that any patent agent is going to ask you? First question he will ask you, is your invention novel or valid? Novel means absolutely new, that there is nothing existing. Now, when we say absolutely new, sometimes, some inventors, they get demotivated. Oh, that is absolutely new. Actually, here absolutely new funda is also there, but also there can be improvements over the existing prior arts. Prior arts means over the existing technologies. For example, like in corona, there are sanitization dispensers were there. So some people, their dispensers were already there for soap dispensers, but then people developed foot dispensers, hand motion detecting dispensers. So these are the improvements over the existing technology. So I would really advise all the inventors to always take notes of the key features of your invention, that okay, I have developed these three features on the of my invention. So what are those three features? Now, first question is your idea absolutely new? Then you will think, is your idea not obvious? So is your idea not obvious means that your idea, it should not be like that's already known, that's quite well known, that's very obvious. For example, a fan is rotating in a clockwise direction or anti-clockwise direction, or it is spinning in half. So that is quite obvious to the technical persons which are already there in that field. Is your idea producible in an industry? Can your idea be produced? It should not be like imagination, like perpetual motion, that that's there and you have invented something, that we say, okay, my machine is giving 100% efficiency, which is not possible. So after answering all these answers to these three questions, you would be able to validate if your idea is really worth getting patent rights or not. Next question the patent agent is going to ask you is, what are the key features of your novel idea? So you should, I already told you that you should make a list, you should pen down the list of the key features. Next is, are there any co-inventors? The patent agent is going to ask you, are you a single inventor or there are more than one inventor? So you can answer that accordingly. So sometimes, a team of the inventors, they work upon a particular idea or a research. Next is, have you disclosed your invention anywhere? Now, this is actually a very, very important question, and people are actually unaware of this fact. Even there are some, clients which I, recently I spoke to. They were professors or teachers from the academic institutions, or the universities, and they were not aware of. They published their research paper, you know, and after 2 years of publishing it, they are coming to us that can that idea be patented or not? But they have already missed that timeline. So after disclosing your invention anywhere in the form of literature or research paper publication, so within 12 months from the date of publication, you must file your idea for patent rights. Otherwise, you will lose that opportunity to file a particular invention. And also, uh, there are some, terms and conditions also apply for experiments or something. Some, law is there. So we will not go into that detail. Later on, we can in our forthcoming sessions. So we really need to tell this information to any patent agent about the disclosure of your invention. And most importantly, sometimes, some inventors, they do this mistake that they share their idea with their friend or colleagues or, somebody else. And sometimes they disclose their idea to even patent agent without signing. Please take a note of this. Without signing NDA. NDA means non-disclosure agreement. Every patent agent, a good patent agent, will always give you an NDA, non-disclosure agreement, an agreement in which the patent agent gives you a signed agreement that he agrees not to disclose your idea to anybody. Now you have disclosed your idea to your friend, and your friend likes the idea before you think or plan to file your patent rights, and he may go to the court to file that idea. So our Indian patent system also works on the first come first basis. So first who is filing, he will get the priority. So we need to be very much careful about this question. Next is, what are the close prior arts? Prior means previous. Arts means technologies. So what are the existing technologies which actually inspired you to brainstorm your new idea or to make improvements upon the existing? Because something, one or the other thing must be there, from which you got that an idea. So we really need to tell that what are the closed technologies. Now, for example, now in this, why the patent agent is asking you this question? Because we need to convince the patent office examiners that this idea is actually an improvement, or how it is different, or how it is solving the problems existing out of the previous technologies. So we need to provide this information in a very, very convincing manner. If we are not able to justify this, then there are chances that, there will be basically hurdles in getting the patent rights granted. So the patent agent has to be very much careful in writing your application for patents grant. So actually, it's just a magic of words. So how you are basically putting the words and the thought process in the drafting application. So it really, matters. And inventors can also draft their patent application. They can prepare their patent application themselves. But then again, there may be a chances. For example, one of my, professor friends, he, have filed for patent invention, patent rights. And, what a carelessness mistake he did. He copied his research paper as such in the patent application. Now, which is actually not the as per the legal requirements of a patent application, and there may be objections on the application he submitted. Now, the last question, that very important question that any patent agent will ask you while filling up the forms to the patent office. There are two terms which are used in the patent application, and 95% of our clients, of the inventors, they are not aware of significance of those two terms, and they get sometimes befooled because of that misnomer. Inventor and applicant. Now both are the different terms, inventor and applicant. Here I just put the picture of Madame Curie. She's an inventor. Now inventor is the one who actually invents. Now you are the inventor since you have thought about that idea. Now what do you mean by applicant? Now applicant is a very, very clear term. Applicant is the person or a company or an organization who applies. Who applies means who is taking care of all the cost of your patent application filing, plus to whom you have thought to assign your application. Now that to whom you have assigned your application, that person is known as assignee. Now applicant can be anybody, inventor himself, assignee to whom the invention is assigned, plus legal representative of a dead, of inventor. Suppose inventor is dead and he has the idea which is left to filing, so his legal representative also can do that. Now, how an assignee and applicant terms, they are very confusion terms for any inventor. A very discouraging and disappointing, I'll just share one experience with you, that recently, we came across 2-3 universities to whom, we discussed ideas. We came to know, to our shock, that they filed the applications, patent applications, with the name of the professor as inventor, no problem. But they also filed the application in applicant, category as inventor's name, when university is filing the patent application, and that invention was actually researched and done experimentation, thought, brainstorming, everything was done at universities level only. In the university you use the resources, their experiments, or lab kits or internet, so anything. So the university must be the applicant, because the university is actually investing into that. Now we were really very much shocked to know that universities, they were not even aware of. Now after the application grant, university will come to know, okay, they don't have any applications on their name. Now actually what happens is, now this is not a mistake of university, this is not a mistake of even the professor or the inventor. I would say this is the negligence of a patent agent who is basically guiding them. So here, if inventors are themselves given this knowledge, that what is actually significance of assignee or applicant. Now when you have invented an idea, now you think, now suppose you are an employee at a university, you have used those resources. Now when you will get the patent rights, exclusiveness rights, you will of course think that you should now commercialize your idea into a product. You should either, what you will do, either you will sell that idea, or you will make a product and you will start selling it and you will have monetary benefits. Now, when you will sell that idea, there will be some profits. When you will license out your idea, there will be some profits. Now, these profits, I could see some participants are raising hands, but I think it would be better if we take question and answers after the session. Okay, thank you.
Yes,
So
yes, please.
moving back now, after going to you have developed your inventions at university level. Now university, when the university is investing into arranging the resources for your invention, into filing the patent application, so why not the profits to be shared with the university? So there will be an agreement between an inventor and the university that okay, this much profit we will provide to the inventor when the invention or this patent is going to be commercialized. Even an employee working at the company may must have to consider their employer as applicant. Now next is, so many clients come up to us and they ask that we don't want to put university as applicant name because this is our own idea. For example, even during this lockdown period, people are really not going to their workplace or academic places, and they must have thought some, they got some new innovative ideas. So now in this situation, of course they would not like to share profits of their inventions with those employers, those companies or academic institutions. Now in that case, then you must seek no objection certificate from your employer, academic institution, or university, college, school, whatever it is, so that later on they don't have to say that okay, you filed your patent application without informing us. So these are the two good routes that one should be really must be aware of as an inventor, that your applicant, sometimes some research scholars they think that okay, applicant is just like we do in research papers, we are adding so many inventors or research scholars or their guides in their research paper name, so it is just same thing. No, applicant or assignee is the one with whom you are going to share your profits when you commercialize your invention. So please, this is very, very important step. Even if any one of you feels that they need to get more clarifications on this, you can always contact us. Okay, now further moving on, who can be the applicant? Just now we discussed inventor himself can be the applicant if he has not used any resources and he's solely the inventor. All the inventors, in case of multiple inventors, all can be applicant. University or employer, any academic institution, legal representative, or to whom the invention is assigned, or we say assignee. I did not write assignee here because that's a technical term. So you may feel difficulty to understand. That's why I wrote to whom the invention is assigned, licensed out, or sold, or it given the rights on that particular patented invention. Now, after determining that our idea is novel, it's valid, we have filled up the forms, everything is being, now application is ready. What next? How to reach to the goal of patents protection? Now in this, firstly, your patent agent is going to file a patent application. File means submit the patent application at the patent office. Now there are two types of patent applications. Suppose you have got an idea, but you think that later on there can be some changes or some improvements in your idea, or your research is not complete. For example, in case of life sciences inventions or engineering subjects, you need some time to do testing and all that. So you simply file a provisional application. Now this provisional application is actually a short application, just securing the date of filing, that okay, we have announced that we have thought an idea, we have submitted it with the patent office. Now this so if anybody comes up with their idea after your date of filing, so but you will be given preference. So it's always better to file this provisional application as soon as possible, as you think upon an idea and that idea is really worth patenting. If you think your invention is now complete, you can file complete application also. But if you have filed provisional application, it doesn't mean the story ends here. You have to file the complete application. Complete means you are giving the complete details of your idea, just like you give the complete details of your physical property while getting registered on your name, that okay, it has these many rooms, this is how it, all the dimensions. So similarly, we need to give all the particulars of your invention into the complete application. And please note here, your complete application will only be examined, will be checked, will be verified by the patent office examiners. Now, after immediately filing for the provisional application, you can apply for funds. Now, Government of India has released some funding schemes for the inventors, for students, for research scholars, for women. There are many funding schemes. So as soon as you file your provisional application, you can submit your application number and little description about your idea to the various incubation centers, to various basically accelerators about that getting the funds. Then you can proceed to develop a prototype. The incubators, they also have some facilities or arrangements of developing the prototypes. We will not go into details of these two things. We'll do that in forthcoming sessions. Now, after filing patent application, your patent application will get published. Now, publication means it is open to the public. That now this application, anybody can see it by visiting website of patent office database. There you can have view of the patent applications, and also there are journals published. So there also you can have an access to what inventions, new inventions have been filed for patent grant. Now in this publication also, now everybody will ask that, okay, when actually application gets open to public? Now, if you apply, there are two norms. One is early. If you want your application to be published, early, then you have to pay some official fees. In 1 month, your application gets published. Or if you want a normal, then it takes 18 months to, after 18 months from the date of your filing application or priority, your application gets published. Now here, sometimes this provisional application, it does not get published, and inventor thinks that he should now withdraw the patent application because there are some steps he missed out, or he want to change the subject, something, any reasons. So you can withdraw your patent application before the publication. Patent application examination. Now after your publication of the application, your application will get examined, will get checked, will get verified if your invention is really worth getting the patent rights or not. There are again two procedures. One is normal, that you can now for normal publication, you need not to file up any form. But for examination, you need to file a request, and that is along with the fees. So which has to be within 48 months, from the date of priority or filing. So I know I am using this priority words and all that. So these we can, discuss in, because this now otherwise it will go too long, this session. So here are the two fast examination. Also, you would want that, okay, this should be done fast and you are really in hurry to get the patent rights, or you can go through the normal examination also. Now, after examination, there will be two routes. Either your application will be rejected. It's not that in one go only the examiner will just reject your patent application. There will be to and fro some response, uh, office actions, in which examiner will say that, okay, these are some points where I feel that, these are some points under doubt, that he does not feel to grant the patent rights. Then you get the chance to justify your points or to modify your application claims, accordingly. Second route can be that your application really gets granted. Now that becomes a kind of a victory. And here I want to, give one more point, that if you want to market your product after filing patent application, you can do that marketing. Now, patent application rejection or grant. Now, suppose your application has been granted, then post grant. Now, this is actually very, very important. Every year you have to pay some fees and you have to give the status of working of your patents to the patent office. Now, next is, there are two routes, normal route and the early route. Early means fast publication, fast examination. So normal route is, it takes around 3 to 5 years, and the cost, if you are 30,000 to 50,000, this is the general cost, because official cost is less, but the patent agent is going to do so many steps for you, so he will have some fees, and it may vary from firms to firm. And if you go through facilitators, Indian patent office facilitators, the cost is even less than 30,000. Early expedited, the cost will increase because there is certain fees, office fees also, which gets developed for examination, and there you need to basically, this is how the cost and time are involved. So in a nutshell, one has to be very, very much careful while submitting their ideas for patent grant. So they need to conduct a thorough search by themselves rather than asking the patent agent to conduct a search. They should do basic search by themselves. Then they should ask the patent agent to do the search if they really feel requirement of that. This will actually save your time and cost if you do a thorough search. And also by having a look that, okay, this much cost, how it is possible. There are many schemes which, like Goa Education Council, there are many funding schemes. They basically help the inventors to file even provisional applications also. So we can have another session entirely on funds and all those things. So far, this is all how you reach the patents from a novel idea. So thank you so much for your patience, for listening me for the entire hour. And any questions, now we can take the questions.